Assalamu alaikum, everybody. Bismillahirrahmanirrahim. I'm so glad to be here today. My name is Fatima Mishu. I'm an employment law attorney in Los Angeles, where I serve as a full-time mediator of employment lawsuits now. On behalf of Imam, the Liaison Office of the Religious Authority of Sayyid Sistani North America, I'm pleased to welcome you to another educational and informative webinar. Today's session will focus on a matter that concerns all of us: how to plan wisely for the future of our children, our finances, our properties, inshallah, specifically whether to choose a will or a trust, and how to understand both the legal and religious dimensions of these options. It's my honor to moderate this panel because, like many of you, I have thought a lot about this topic over the years, but I'm often overwhelmed by even getting the process started. So inshallah, today could serve as the running start for many of us to get the process going. Despite being an attorney myself, and as you will learn today, this topic is not easily manageable on your own. And so we are very grateful today for Imam and for being able to have this conversation. A heartfelt thanks to everyone who worked behind the scenes, and to Imam particularly, its Shia Muslim Professionals Initiative, for investing in the talents of our community. By selecting important and timely topics such as this one, the initiative raises the cultural and intellectual standards of the Shia Muslims across North America and strengthens our community's role in this part of the world. I'm honored today to be joined by two distinguished guests, Sayyid Muhammad Rizvi, a renowned scholar, author, and expert, and the Imam of the Jafari Center in Toronto. Welcome, Sayyid Rizvi. And Sayyid Ali Tawfiq, a lawyer, scholar, and community activist with many years of dedicated religious and educational services in the Washington, D.C. area. Welcome, Sayyid Ali. Our goal is to leave some time for questions at the end. So if you do have questions that are not answered during today's conversation, you can type them into the chat in the comment box. We'll do our best to review and answer some of them as we go. And if they aren't answered, we will try to have some time at the end. But without further delay, we will go ahead and get started, inshallah. And as the very, very important topic gets started, and as you often hear from lawyers, we must start this conversation with some disclaimers. Ali will go ahead and take over from here.
Yes, Bismillah ar-Rahman ar-Rahim. I want to start off by saying I am an attorney. I do practice estate planning law. I do wills and trusts on a regular basis. So I am an attorney. I am an estate planning attorney. However, I am not your attorney. The purpose of this webinar is not for me to serve as your attorney. My advice to everyone is please find an attorney as soon as possible. Now, finally, just right off the bat, I want everyone to understand there are going to be a lot of fantastic questions, a lot of questions that are very relevant to each and every one of us. However, it is my job to inform you of the different considerations, and my answer may not be what you are specifically looking for. My answer will predominantly be, it depends. So this is a webinar, an informational webinar. The purpose is not for me to give legal advice. I am only providing legal information.
Yeah, and Sayyid Ali, I would think that a lot of people these days are going to be relying on AI to give them a lot of answers. And if your AI is not saying as part of the answer, it depends, then you should make sure to double click on that. Because at the end of the day, so much of this is nuanced. And inshallah, by the end of this, you have some basis to start your exploration, each of you that are attending. But you won't necessarily have the answers to all your specific questions, unfortunately. And so what we're going to do at the very first thing is answer, I think, probably the most important primary question: what is the difference between a will and a trust? And I think a lot of people have seen Islamic wills available on the internet, and alhamdulillah, Imam has provided a template of one. And so the question everybody first has is, can I just use one of these templates? Is that adequate?
Yeah, and there are so many templates out there, both secular oriented templates, state forms, and there's all these Islamic wills out there. And there's, we're all familiar with the importance of having an Islamic will. And people, because, may misunderstand, thinking that they can just fill out an Islamic will and be done with it. Now, there are a lot of considerations to be made. It's not as simple as filling out an Islamic will and expecting it to be implemented the way it's written in the will. There are laws that allow for overriding a will. There are different categorizations of property that are relevant. And so just picking up an Islamic will, signing it, and hoping the court will enforce it is not the best, or the most appropriate way of navigating this. And so I kind of want to take a step back and understanding what type of tools are out there for estate planning and for transferring assets upon your passing. And so that's where the conversation of like wills and trusts comes into play. People think that an Islamic will is the same thing as a legal will, but that is not the case. Each has its own function and understanding and implementation. And so we're going to kind of cover some of those in this webinar.
So you can start here. What happens when you die?
Yeah, so let's just kind of simulate all of our passing. Yeah, from what I've understood, the majority of Muslims, I want to say 90% plus Muslims in America, do not have a will or a trust or any estate plan. Now, the way the system is designed in North America and predominantly US, this is going to be a very US-centric webinar. When you transition to the barzakh, your family is being sent through what I like to call hell, and the dunya version of hell, and that is the court system. Now, for those of you who are not familiar with the court system, it is a place where people are seeking a form of justice, but end up finding more hardship and difficulty. And when someone passes away, most times people are required to go through the court process in order to receive their family's assets.
Why is this relevant? Yeah, can people, what about the assumption that I think a lot of people have is, well, my father passed, where there's no dispute between us, can't we just handle this ourselves? Do we really have to go through a court system?
Yeah, so for the majority of cases where there is a will and where there is no will, it doesn't make a difference. If there are assets left in someone's name, they have to go through the court system. It's not that you can internally figure it out. There is going to be a court oversight. There are notice requirements that people are not familiar with. Now, some people are, depending on how things are titled, automatically receive title to an account or an asset. But for the most part, that is not the case. So we're going to cover a couple estate planning tools and just kind of define what these are. The first tool that people use to transfer assets when they pass away is a will, otherwise known as a last will and testament, a final will. These are all different ways that they are presented. They're synonymous. So a last will and testament is nothing more than a statement of wishes on paper, meaning you're just kind of stating, this is who I want to receive my assets. Here's the person who's going to be in charge, signed, 2 witnesses, we are done. Now, this is a valid will. However, it's not activated until you pass away. Your executor still needs to take this piece of paper to court. And that process takes anywhere from 6 months to 2 years on average. It could be anywhere from 6 months to 20 years, as I've seen. And the cost is anywhere from $3,000 to $300,000. It really depends on the circumstances of the family and any debtors and all that. The second tool that's used for transferring assets is a revocable living trust. Now, people throw out the term trust all the time. There are all sorts of trusts out there. We have irrevocable trust, Medicaid asset protection trust. There are so many trusts out there. The one that I'm talking about is specifically a revocable living trust. Now, this is like a treasure chest. You transfer your assets into this chest right now. You're no longer the owner on paper. On paper, this chest is the owner, you and usually a spouse. And then you select successor trustees. This means that if you are incapacitated or you've passed away, now there's someone who has access to it. And then they follow your instructions. Now, just to compare these two different tools, let's talk about some of the differences. So the will and testament, if you look at the top left of the screen, it needs to go through the probate court process. Probate is the name of that court that deals with when someone passes away. It has to go through court. You don't have a will executed or managed outside of court. Number two, it's all public. If someone's passed away with a will, we can pretty much Google it. It's in the county records. You can tell who the beneficiaries are. You can see the case docket and all of that. And then three, wills are very cheap. They are very cheap to use, and that's why you see all these different templates out there. But on the back end, there is a lot of cost associated with it in terms of attorney's fees, court costs, executor fees, etc. On the other hand,
and I do think that you were mentioning, when you say expensive on the back end, if you're using a template, what do you think about the utility of that will?
Yeah, so what usually happens is that someone kind of downloads a template and then they fill it out expecting the will to operate a certain way, and the family's expecting it to operate a certain way, and then it just doesn't because of the way assets are titled and whatnot. And then it causes conflict in the family. And the moment one disgruntled family member starts dragging their feet in that process, the price kind of exponentially increases, going from $2,000 to $20,000. Now, a revocable living trust does not go through court. Everything's already put into this private treasure chest. There's already instructions on how things are to be distributed. And so there's no publicity, there's no court. It is somewhat complex because, there are multiple documents associated. It's not just as simple as having a 2-page, 3-page will. A living trust usually is from like 10 to maybe 100 pages. And naturally, when there's something that's more complex, there's a cost associated with it. So that has a price tag. It can be a little pricey, but on the back end, you're saving your family from that court process and all the funds that they have to give to the attorneys and the executors.
And Said Rizvi, do you have an opinion from an Islamic perspective, off the bat, what our responsibility is while we are alive to think through these implications after our passing? Let's assume that after our passing, we have something that at least manages the very bare minimum of the religious obligation. And how about our ethical religious obligation today to think through these things?
Well, Bismillah ar-Rahman ar-Rahim. Well, let me go a little bit back where we talked about the importance of it before I talk about last will or living trust. First of all, just to give a background to especially the majority of our community members who come from the eastern part of the world. If you live in a Muslim country or even in a secular system like India, for example, where they have something known as Muslim personal law, where marriage, divorce, and inheritance is governed even by the secular court according to your faith. In those countries, you don't have to worry about these issues because, whatever will happen at the end, it's going to happen according to the, our Sharia. Even, for example, in India, if you go to the court and it's a Shia family have a dispute on the inheritance, a Hindu judge has to actually look at the fiqh, Ja'fari fiqh, to find out what would be the judgment for this case. And that's why, in the eastern part of the world where Muslims are in majority, these issues are not really discussed in that way. It's only when we come to the western part of the world, we are a minority here. This is where we come to realize that there are things that we have to take care of it ourselves. It becomes our religious duty here to make sure that the the estate is going to the next generation according to the our religious values. Because if you see the system here, whether it's in US or Canada, allows you to dictate what you want to do with your estate. And since the permission is there and the right is there, it becomes obligatory for us to exercise that. Because if you don't do that, as you already heard, the uh, especially when the dispute comes up, the government gets involved, the court system, and it will be costly. Secondly, the decision made by them, or even of dividing the assets, would not be according to the Sharia. So by not having anything there, you are actually opening the door to a non-Islamic, authority to come in and dictate what is going to be done. And these are serious issues. Sometimes we don't think about it. If one member of the family gets more than his Shari'i share, that is ghasb. Religiously not valid for him or her to have it. And so this is a very important issue. And I'm not giving a fatwa, but I would say it is wajib in this part of the world to work about it, whether you have it in form of the last will or living, trust, but you have to plan in that way. The other issue is that, if you do everything according to our values, and then a member in the family, disgruntled a fellow, doesn't agree with what he or she is getting, and they go to court, maybe then it's not being divided the way you want it. At least you, who are is in barzakh now, at least you will be peaceful. Yes, your family member, the way the chart shows, will be going through hell in this dunya, but your responsibility would be over. And so even if it is not fully implemented the way you wanted, it is your duty to make sure that at least this is your will, this is your wish. And so whether you use this vehicle of the last will or the living trust, it has to be managed and worked in such a way that your heirs basically get whatever there is their rightful share, and nobody is deprived from their rightful share. That is the main issue that I think people have to keep in mind, whether you go for the last will option or the living trust option.
Okay, thank you for that. And so I'm going to put back to Sayed Ali.
Yeah. Absolutely. Yeah. I mean, as Maulana was sharing, it's important to be proactive about it. And that's your responsibility, to make the decision before it's made for you and for the rest of your family. Now, there's a third vehicle that many people are already familiar with, and that's called beneficiary designation. So for those of you who have retirement accounts, like a 401k or an IRA, or I believe it's called something else in Canada, you have more likely than not assigned someone to be the beneficiary of that asset, meaning that when you pass away, that financial institution, Fidelity, Vanguard, whoever may be, JP Morgan, has instructions to distribute that account to the beneficiary that you chose, and usually it's a spouse. This is a vehicle. It is a vehicle for transferring asset because it happens immediately when you pass away. So these are three different ones, and you have to kind of consolidate them and figure out which one is going to be the primary one for you and which ones are going to be more secondary for you. So many people, for example, will write a will or an Islamic will thinking that everything will be distributed based on that. But if you have your retirement account, if you've designated a beneficiary for that retirement account, your will is not going to do anything. It's all going to be distributed based on the account, not based on your will. Your will only handles things that are left in your name when you pass. So these are the three mechanisms or three tools.
Can I, Brother Tawfiq, we go back to the slide, please?
Yes.
So the issue of, the third beneficiary designation, this is limited, isn't it? You can't use, this doesn't cover all our assets.
Very, very important point. So it doesn't cover all assets. However, in some states, it can cover almost all assets. For example, definitely for retirement accounts. What people don't know is it can apply, you can even use this for bank accounts. You can use this for vehicles. And in some states, you can use this even for property, like a house, or even a commercial property, real property generally. Not for all states. But if you own, for example, a business, it doesn't work that way.
So then this would be combined with the last will or the living trust.
Exactly.
It
And
can't
so
stand
part of
by
estate planning is actually potentially choosing the trust as a beneficiary to those accounts.
Like, for example, if you look at the life insurance,
Yeah.
you designate somebody as the beneficiary. From my perspective, and maybe some other colleagues of mine might not agree on that, but I have looked at it very carefully. Once you designate somebody the life insurance, that money doesn't exist now. I'm just paying the monthly premium, but the money is not there. The money is going to be created after I pass away. And when it's created, it has the name of the beneficiary. So it's not even part of the estate and inheritance, because it was generated after my demise, which calls that, but it's not mine. It already has a name on it. And so that, there's beneficiary designation that will be very relevant in that case of life insurance.
Absolutely. Absolutely.
And so you keep referring to estate plan and estate planning. Can you describe now, kind of in a big picture, how we should be seeing all the elements of each of them?
Yeah. So just to translate estate, this fancy term, your estate means your stuff, whatever belongs to you. And an estate plan is how you have planned for your stuff to be transferred or used when you pass or you don't have capacity to use it. And this is, we talk about the will, we talk about the trust, we talk about beneficiary designations. This is just one vehicle or one important component of an estate plan. An estate plan is a binder. It covers all sorts of scenarios. So for example, when you've chosen a beneficiary for an account, that only activates when you pass away. Well, let's say you have dementia. Let's say you are in a coma. You don't have the mental capacity to be able to receive the money, let alone use it, or your family to have access to it. And I've seen cases where when people don't choose or don't have some of the other documents here, that money gets locked up and some families fall behind on the mortgage because they were relying on someone's retirement account. So let's go through this estate plan. An estate plan is either will-based or trust-based. And that just means, what's the main tool that you use to transfer the asset? If it's a will-based estate plan, you have the bottom half here. You have your will. That takes care of all the assets when you pass. You have your power of attorney and healthcare directive for incapacity purposes. So if you are incapacitated, with the power of attorney, someone can make financial decisions for you. They can collect the retirement account funds. They can, deal with the bank. They can sign property for you. The healthcare directive is for medical decisions, and there's a whole area of Islamic law and state law related to that. But at least someone should be able to make those decisions. And final disposition is for, burial instructions. Very important as well. Now, a trust-based estate plan has the bottom half and the top half. So there's the trust, then there's all these associated documents with the trust, and there's the bottom half too. Each serves its own function. Now, I'm gonna kind of sorry, go back one slide, please. Just it's mentioned
Straight
there that you can see there's a big cost discrepancy between the two of these. The will-based estate plan is pretty cheap, relatively, for an attorney to kind of draft, and you can kind of reach out to attorneys around you, and you'll find anywhere from $500 to $1,500 for them to prepare a will-based estate plan for you. It's not just a will; they're going to try to help you prepare for all circumstances. And trust-based estate plan will range anywhere from $3,000 to $7,000. Now, some states will cost more than others. There are more complexities, and also your circumstances may require for you to have more charge.
Does this include people who own a business? These ballpark numbers?
Yeah, handling a business is actually not complicated when it comes to estate plans. That's more on the business side, operating agreements. The trust, when it comes to the trust, it's not much. There's not much management involved.
Okay, and are all these 8 elements applicable in all 50 states and Canada, or is there, some states might not have some of these elements?
Yeah. So pretty much every state, I'm going to generalize here because I'm not familiar with all the different states. Almost generally speaking, all states use this metric or use this framework for a trust-based estate plan and a will-based estate plan. I am not familiar with Canadian law, whether they use all of these different documents. There are variations of that. And the functions for this are also very different. So there are potential tax consequences for having a trust in Canada that are not the case in America. So definitely when it comes to Canadian law, at the very least, you should speak with an attorney and think whether, and discuss whether a trust or a will is more appropriate for you. I mean, everyone should do that anyways, but it's possible that in Canada, a will suffice more than a trust, whereas in the States, it's more leaning towards a trust.
But when you bring up the word trust or estate plan, and this is a question that just popped up, don't I need to have a certain amount of money to be somebody who makes a trust, creates a trust, has a living trust, or how much money what's my minimum savings that I should have before I create an estate plan? Assuming you have the money to get your attorney and create it, there is a notion that there is some wealth, this level of wealth that needs to be met before you should be doing these things.
Yeah, and the perception is that you have to be in the millions. You have to have 7 figures plus, but that is not necessarily true whatsoever. It's not about how much does it cost for you to make the trust versus the will. It's how much do you expect your family to pay on the back end based on your assets. That's what should actually be calculated.
Yeah, I feel that the reason we associate estate plans with the wealthy people is because those wealthy people have thought about their wealth enough and the nuances and the fights that come after that they're the ones that oftentimes have planned for this and gotten their attorneys and gotten everything lined up. But it's not at all reserved for them, and it shouldn't be perceived as this is a wealthy person task. This is for all of us, correct?
Absolutely. And so let's talk about a typical family, Muslim family, husband and wife with 3 kids, minor kids. And the only asset they have is a house and maybe a retirement account. Then this house, we'll say, is worth $300,000, $400,000. When this person passes away, let's say the 2 parents both pass away. It's easier for our hypothetical. Now the family is required to go through the court process and have it distributed amongst the 3 children with a guardian, assuming the kids are minors. And there's a chunk of that goes to the attorney who's helping process that. There's a percentage that some states allocate for the attorney that helps you distribute. But if it wasn't a trust, then the trust can pretty much hold the assets with the help of a trustee that you've already designated. And then there's no need for court whatsoever, and you've protected the $300,000 home.
And so let's ask this question.
Can I if as a follow-up to that, Brother Tawfiq, so let's say in case of the will, we normally have to designate somebody as the executor.
Yes.
So then, do we need a lawyer after that? An
So
attorney?
in most, in I want to say like half, maybe a majority of states, the court system is so complicated that you will not be able to do it on your own. The average person will not be able to do it on their own. They'll have to hire an attorney to get it done. Otherwise, it gets delayed for months or years.
And so
I
what
have-
about, go ahead.
Yeah, as an example, I found like there was a case that we were working on where there was a single daughter of a mother who passed away in 1995 and was not able to go through the system to be able to just have that house transferred into the sole daughter's name 25 years later.
25 years. But that would be very exception to the norm. Come on. It's probably one of those worst case scenarios.
Yeah, in her case it was, but the thing is that if the process is not followed and you don't get that final court order after following all the different procedures, then it will be prolonged for 2, 3, 4 years, which is very common in different states, and especially California.
Okay.
There are, just as an example, the probate system requires you to give notice to, for example, Social Security, the tax board, and all the potential creditors. You have to publish this person has passed away in a newspaper. You have to give notice to all potential heirs and beneficiaries, whether they're listed or not. And all of that, people don't know this entire package and checklist, and they don't always follow the requirements. And so when they go to the judge to say, all right, can we go for distribution? They say, well, you haven't done this, and then you haven't done this, and you haven't done this, and just keeps pushing it back month after month after month. And the judges' dockets are always very full. And mashallah, they don't want to hear your case.
Okay.
So what about Canadian law?
Well, I have done some research in Canadian law just to understand the difference between how they operate between the U.S. and Canada, and they're significantly different to the point where I will not comment. You should definitely speak to a Canadian attorney on the difference between wills and trusts and what's best for you, let alone what's best for the general public.
And I do believe that there might be a couple people joining from the UK. Any thoughts on the UK briefly?
That's even further out. I cannot comment on any other legal system.
It does. There will certainly, for anybody who is in Canada or the UK, the technicalities may very well not be the same, but the principles in a lot of these will likely be similar, and the burdens that are going to be discussed will be similar in a lot of ways potentially. So I do encourage anybody who is in Canada or the UK to continue listening in, because while the specifics may not exactly copy paste, not much is going to copy paste, even if you're in the US, right? What Said Ali mentions is you're not going to necessarily be able to apply the same in California or Chicago anyway. So the information you get today shall help you understand the priorities when you do find the appropriate attorney to navigate for your specific jurisdiction, inshallah.
Sure.
So let's talk about probate cost per state.
Yeah, so this is now answering the question that everyone has on their mind: should we have a will? Should we have a trust? And once again, if you were listening in the first slide, my answer is it depends. And now it's not just a cop-out for me as an attorney to say it depends. It really does depend on a lot of factors. And so I'm going to go through a few factors to help clarify why it depends. So each state has a different probate court process. Probate, remember, is the system that you have to go, the court system you have to go through when you pass away. And so California is notorious for being one of the most difficult states in the country. Texas is a lot easier. And then there are some states who kind of pride themselves in being an easier or more lenient probate system, but that's something to think about. Another factor is tax considerations. Now, I want to address a misunderstanding, and that is that when you die without a will, the state takes everything. At least in the United States, that is a myth. It's possible in some cases, but for the majority of Americans, that is not the case. And many people they want to make an estate plan to avoid tax liability. Again, for the majority of Americans, I want to say 90%, maybe a little less than that, there is no tax liability. As it stands in 2025, the federal estate tax limit is $14 million per person. As in, you and your spouse is $28 million. So if you have less than $28 million, you and your spouse, federally, there's no estate tax, at least this year. We'll see what our authorities have in store at the end of this year. Now, some states do have estate tax, and they have an inheritance tax, and their threshold is very different. So like Oregon was at 1 million, Maryland, 5 million. And so these are different considerations for why one would be favored over another, depending on what your net worth is.
When you're referring to this, are you referring to what state you go? Like, let's say you have a family member who passes in New Jersey, but you are in California. What state tax considerations come into play there?
Yeah, so the person who passes away, the state that they reside in matters, or the state that their assets are in. So if you live in California and your parents are in New Jersey and they pass away with a certain amount and they gifted it, via inheritance or via will to you, there's a potential tax liability that you need to think about.
And so if you are then wouldn't you also say then if you're a person who intends on, after your passing, some of your assets will leave the state you're in, having a will means going to court.
Yes.
And going to court means the state that you reside in, pass away in, or have your assets in, right? So if you have family members outside of your state, isn't that one of a very case specific consideration of somebody that says, okay, maybe actually I need to go the trust route instead of the will route, because to enforce this, they're going to need to come over to me.
Absolutely. Yeah. If you live in Idaho and the rest of your family lives in Florida, they have to go back and forth between Idaho, or at least hire an Idaho attorney to go through that process. And so a trust would kind of minimize that to potentially removing that. All right, another important factor, and this is what I like to consider the hardest part of Islamic estate planning in America. And that is not what the distributions are, but what do you actually own? Most husbands and wives do not have this conversation amongst themselves as to who owns what amongst themselves. There are assumptions, expectations. Now, number one, please have that conversation with yourselves, amongst yourselves, to clarify who owns what. But separately, let's talk about how the law determines your assets. So if you are married and you live in one of those yellow community property states, every dollar you earn, every dollar you owe during your marriage is 50-50, but not in those equitable distribution states. That just means everything's on the table. And they have other entitlements in case you pass away. There are some states that say, let's say you write your will and you say, for example, 1/8 to my wife, 1/6 to my mom, 1/6 to my dad, basically have all those distributions. State law allows your spouse to override the will, depending on the state that you're in, and the percentage matters based on the state. Some will say, for example, 50% they're entitled to, in addition to the 50% that they already have. So
that's if she goes to the court to challenge that, isn't it?
Correct.
If she accepts that 1/8, for example,
yes,
then there will be no issue.
Correct.
Okay.
Yeah.
What I have a question on that. If you go
Sure.
back to the marital, one of the issues here, I think, and I'm not 100% sure about it, that if the property or even the joint bank accounts and anything else which is in the name of both the spouses, if one of them passes away, automatically it goes to the other, and there is no tax implications. But if it is to be distributed between, let's say the husband dies, now it has to be distributed between the wife and the children, then at least the children's portion will be hit with taxation.
The majority of the time, there still won't be a tax implication.
Okay.
Most states, if not all, or counties, some of it's county law, some of it's state law, they have an exemption for parent to child, meaning that there won't be a tax for that.
Oh, okay.
But you brought up an interesting point, because not all assets are titled as joint tenants with right of survivorship. And that's the key word here, with right of survivorship. Right of survivorship means that the survivor takes all. Whereas you can still be husband and wife, own property, but it'll be titled as tenants in common, for example.
Yeah.
And that means each person's share is respected. And your will manage that share.
Yes.
And community property also complicates things further, because let's say you have $1, or let's say your 50%, you've earned, let's say $200,000, and then you use that $200,000 to purchase a house for your mother. That money never came into your spouse's account. Your spouse now kind of co-owns that with your mother. It gets traced wherever that dollar goes.
Okay.
Yeah.
And we have a lot of people are asking the question, well, what about the Islamic laws? We will get there, inshallah, for everybody who I know that we're itching to understand, well, how do we've heard about the 1/3 rule, we will get there, inshallah, soon, but we're kind of go in turn. So the next question, or the next issue, is transfer tool methods.
Yeah, so if you remember, I talked about beneficiary designation. So in these states, they allow transfer on death deeds, which basically means you submit a deed to the county saying, if I pass away, here's who gets the house, for example, or here are the 3 people that get the house, equally or not equally. And some of these states have actually been passing newer laws. So New York just recently passed a law allowing for this as well. Important tool.
But if you get an estate plan attorney, this will all be wrapped up in there, right?
Absolutely. So a estate planning attorney would help you figure out which tool to use. Not necessarily just try to push a trust down every client's throat, but use the one that's most appropriate for you. And then the fifth important element is not everyone has the same type of assets. So some have a house and an account, a bank account and a retirement account. It's very different from someone who actually owns, let's say, a business or a family business, or has other multiple investments. And so these help help you personalize your estate plan. So in summary, which one should you have, a will or a trust? The answer is, it depends, and here are a few considerations to have.
Okay. So let us now talk about the Islamic implications. We want to hear from the Islamic perspective. Is there one of the various methodologies that we should be leaning towards, or not? And what are the tools we can use to enhance our understanding of the Islamic rulings on this issue? Said Wasi.
Well, as I mentioned earlier, that for us living in the West, it is absolutely important for us to make sure that there is a document left as a last will, or whether you're talking about living trust, so that you are able to manage the distribution of your estate within the family according to our values. There is nothing which prevents, because nobody says, no government would say, oh, you're not allowed to use your own, distribution system. Of course, unless a member of the family challenges and it goes to court, but at least you would have done your duty as far as the faith is concerned. And so that's the first thing, the importance of writing the will according to the Islamic perspective. Um, then, of course, there are many differences which comes in, and I think if you look at the shares, and that's, I think, one of the important things that everybody should keep in mind, that we have this general principle of one third, two third issue, where you are allowed, because the question comes up that after I pass away, do I have a right in what is going to happen to my estate? In Islam, you have that right. In your lifetime, you can do whatever you want. But if something is to happen after I pass away, that's where you need the will. Without the will, it wouldn't work. And that would only apply, your discretion is only in one third. Actually, in Islam, the term wasiyya, will, is actually only applicable to one third. The two thirds are automatically governed by the shares which are given in Islam, according to the laws of inheritance. So this is important to keep in mind, that if you want things to be done after you pass away, then you have that discretion of one third option. You can use that in different ways. You can use it to change the shares of the heirs. Especially we hear this issue, oh, I would like to give to my son and daughter equal. Well, this is one way you can do it according to Sharia. So you use the one third option to change the shares there, so that the son and the daughter, for example, get equal. Or if you want to make sure you want to give more to your wife, not just 1/8. This is where the one third option is very useful and very important to know about it. It's not only about changing the shares of the heirs. You can also use it partially for your sadaqah jariyah, your perpetual charity, where the reward will be increased even after you pass away. And so there's a lot of leeway there. You can give it to whomever you want, within the family, outside the family, to institutions that you think are doing very good charitable work. So this one third option is very important one to know, and it can change many things. And so if you look at this chart there, you will see that in my book, I have actually given about 36 most common variations and situations there. And what we see there is basically, um, if I may just look at it here. Yeah, for example, in the first two pie charts there, Sister Fatima, if you go to this one, yeah, you see here on the left one, this is out of 100% of your estate. You didn't exercise your one third option, and so we're looking about a case where a person is leaving a parent, wife, a daughter, and a son, and this is what the ratios would be. But then on the other side, you will see there is a one third written there, and that's the one you can actually change around. Not the entire. You can use a portion for giving to your wife, to your daughter, so it becomes so maybe 15% more from 33rd the 33% going to the daughter. So it will, in a way, equalize the share of this son and the daughter. Similarly, when it comes to the share of the wife, um, and so that they're, this is a very useful element of, the exercise of using one third option.
So both of these charts side by side represent, let's say somebody's assets are $1 million.
Yeah.
Both of them represent $1 million, but the one on the right says what happens with the 1/3 if it also exists as part of the $1 million, correct?
Yeah.
Okay. Somebody
And
had
so that,
yeah.
yeah, so that 1/3 now can be, you can move it, so, somebody wants to give the whole 1/3 to the wife. Yeah, you just add that to the green, share there. Or you can divide it, according to different, proportions, and give it to the daughter and the wife, for example. And of course, that will somehow reduce the share of the son there. And so it's a very flexible tool that Sharia has given to us.
And so from an Islamic perspective, is there any methodology somebody is supposed to utilize to designate what happens to the 1/3? Let's say they do want to exercise an opinion on that 1/3.
Well, I think looking at the scenario here in the West, normally, vast majority of the people in the community, for them, the biggest asset is the residential home, the property. And it is basically in the name of both husband and wife. And, so for example, in Canada, I think in the US, it should be the same law that if the husband passes away, the entire property goes to the surviving spouse. And this case would be the wife, for example. That's where the tension comes in. And and so from the Sharia point of view, if both of them are named as the owner there, they only actually have ownership of half of it, and so other half is the share of the deceased, and that has to be divided among the heirs. So that is where the practical problem comes up. And what do you do there? What I have suggested in my book is there are different scenarios there, and the best one would be that, if your assets are not limited to your residential home, your a business of millions, then you just gift away the whole house in your lifetime to your wife, as long as you are sure about it. you know that that the relationship will be maintained. That will be the most easiest way of dealing with that.
Sorry, I do have a
um,
clarifying question there. You
yeah.
said you gift away half to your wife. So right now, my husband and I, do we in our life, I gift my half to you and you gift your half to me right now, but because it's a two-way street, right? In terms of the half.
It can be given in that, in the Sharia there is a concept called hiba mashruta, conditional gift. So what you are saying is that I, gift my half of the house to you, with the condition that, if you pass away before me, then it will revert back to me. That's the conditional uh, clause there, and the other way around. If they do that, then there is no issue. Then the whole property will go to the surviving spouse, even from the Sharia point of view.
And so, Sayyid Ali, from an Islamic perspective, from a legal perspective, mixing this Islamic concept, is this something that could be done in a living trust mechanism?
Yeah, so a living trust kind of gives full freedom on how you want things to be distributed or owned during lifetime and also when one of you passes away or when both pass away, and how things are to be managed at that point. So the living trust gives a lot more flexibility in that regard.
And we are getting a lot of questions that people are asking specifics. What if my parents aren't alive? Or what if I don't have any sons? And those types of questions. And I think it's important to go back to this slide right here where there is, say it has a book available. It will have not only these 4 examples of, parent, wife, son, daughter, and parent, husband, children, etc. It will have many, many more examples. And so we do encourage everybody, you can access this book. You can get it, or you can, find other resources as well. We're not going to be able to answer every scenario. And the reality is by the time of our passing, we don't know what that scenario even looks like. So we will do our, each one of us have an obligation to kind of, I guess, do the work right now and prepare for all scenarios. And so those resources are available, but we won't just be able to answer every layout of family dynamics today.
Yeah, and basically the charts that I have, starts with this scenario with there's only father only as a or sole survivor, or both parents, or mother, and then it goes to the wife and parents, or husband and parents, or the spouse and one parent, and then the scenarios of children come in. So they all do different, shares. Of course, we all earlier in that book we have the chart which gives the ratio for all the heirs, but the chart makes it easy to understand. So you can just go to your specific situation, pick that chart, and you don't have to worry about all the others. This is only when I was working on it initially, I thought, we might end up with more than 100 charts with all options of 100% or 1/3. I said, we don't want to do that. We'll just go with whatever is common. Yeah.
So I want to go to this slide. Said Ali, if you can jump in here on talking through our options now.
Yeah, so I just want to also point out that it's relevant to the previous slide and also this slide. Here's what you should not do. You should not write a will and say, I want everything distributed according to the Sharia. That is extremely vague. It has to have the percentages clearly allocated. Because no judge is going to understand what the Sharia means and then also understand the nuances of the different madhabs and circumstances. It's just not going to be implemented that way. So there are two
if I may just sorry for interrupting, Ali.
Sure.
Just make a point there that I think the way I've seen these scenarios and some of the cases, with this whole Islamophobia in the West, whether it's in Canada or US, more in US, you have even cities and states passing law that no Sharia, although nobody's trying to enforce that on the society. So already there is a backlash at that. So my recommendation would be that write your will according to the Sharia percentages and the shares, but don't use the word Sharia or Islam. You're just talking, this is what I wanted to do. What you want to do is according to Islamic faith, but you don't have to put that on the paper. Because if it ends up in the court, as soon as they see the word Sharia and Islam, the judge is going to be biased anyway. And so my recommendation is don't use the words Sharia or Islam in your will. Just say, this is what I want. And let that be the Islamic perspective.
And I think I would love to get to this slide where I think Sayyid Ali's going to have a nuanced alternative to putting those specifics in the will, correct? I mean, well, in the document that goes before the court. So let's go over here.
So there are two different options, and we'll start with option one. And just this is the basic understanding of how we expect things to be distributed when we pass. So we write a will, or we make a trust. Either way, we're basically asking the court to enforce our will and give our assets to our family members. So in a context, let's say you're a Muslim family who wants to make sure that everything is distributed according to Sharia distributions, you could, in theory, write all the distributions. You put the 1/8, 1/6, 1/3, whatever you like in your will. Now the court is going to oversee and enforce that all the different family members get their share, minus the cut that the process takes. For many families, this is probably the most appropriate. However, for many more families, I want to potentially suggest an alternative. And this is something where you really have to have a conversation with your attorney and with your, let's say, religious advisor, scholar, who will help you navigate the circumstances here. The second method, which I do advise for a lot of families, is try to eliminate or limit the amount of exposure and time you spend in court. Now, that's one of two ways. One, by making a trust, you're already limiting it. But two, by choosing a specific person as a beneficiary, such as your spouse now has full legal title, ownership. And you can have, for example, an Islamic will or instructions on the side as to how those assets are to be distributed. Now, this will not work for all families, but the purpose of the second method is to avoid court exposure. So when, for example, your wife or your husband or your son now has full legal title, that's what the will says, that's what the trust says, that's what all the legal documentation state, the rest of your family does not have legal standing to fight it. And so now they have to resolve it internally. And it has the best chance of
I want to
prevailing.
recap what you were saying, because I do want to make sure everybody understood this. In this option 2 scenario, the estate plan says everything, absolutely everything goes to my husband, my wife, or my eldest child, whatever. And if they're not around, then it's the next person. And if they're not around, then it's the next person, right? But everything to one person, and in legal paper, there's nothing referring to our Sharia expectations.
Correct.
And then you said on the side or separately, outside of the expectations of the courts and the legal system, the reason you pick that person was because you do expect them and trust them to follow your side request, which is to follow the Sharia.
Exactly. So from a religious standpoint, you have appointed that person to be the Wasi, the executor, from an Islamic standpoint. But from a legal standpoint, they are the beneficiary. So again, there are a lot of considerations here. Definitely speak to an attorney and scholar to decide what's best for your circumstances.
But if there is a separate Islamic will, if dispute comes up, this will not hold on in the court, huh?
So it really depends. Yeah, if someone prepares an Islamic will and follows all the legal requirements for a valid will, for example, signing it with 2 witnesses, and it has those requirements, then yes, now it's fighting the existing estate plan. But if, for example, it says this is a non-binding Islamic will that should not be used in court, has no legal standing, and I'm not going to have 2 witnesses, for example. Or you may have the 2 witnesses, but you're saying there is no intent for this to be my last will and testament to be implemented in court. It won't operate the same way. There's no dispute.
And theoretically, the beneficiary is the person. So if the beneficiary is your spouse, the beneficiary is the only person getting that document anyway. Your children or your uncle or extended family isn't necessarily ever even seeing that. That could live exclusively in the hands and possession of the person who's responsible for it. Now, what if you want to have 2 people responsible for it? Now, you still, in your estate plan, you made a single beneficiary of your spouse. But let's say you're like, I don't know if my spouse is really like they're my most trusted person, but I don't want to put the burden completely on them to do the Islamic portion of it or to figure it out. What are the options there?
Yeah, so there's no restriction on it being just one person as the wasi from the non-binding Islamic will standpoint. The idea is that you have given these instructions. You could also share it with the rest of your family. And now one thing I did is I actually prepared a template, non-binding Islamic will, which you have an opportunity to also explain your reasoning for why you did what you did, why you prepared your estate plan in this fashion, and the expectations and assumptions are clarified beforehand. It's also very important, I feel, for everyone to have this conversation with their family and not just secretly make a will, because let's just say the chaos that ensues, you may not be around for it, but it can cause, a lot of problems.
But the risk element is still there.
Absolutely, yeah. And so basically the risk is preserve the asset for one or two people, for example, who are potentially withholding it from the rest of the family, versus the entire family receives their share minus the cost of fighting over that share, which may deplete the asset entirely. And I have seen that repeatedly. So if the family's on the same page, we don't have this concern. But if the family, for whatever reason, is not on the same page, or, then that's where we have a concern.
And I mean, in both of your experiences, I would like you to speak to a little bit about, from the perspective of me, I might think my kids are going to get along after I pass, and I might hope or expect that, and I might write my will today. But in 15, 20 years, 30 years, whenever that is, that will becomes the document that actually matters, or I pass, we can't predict at that point what's really going to be happening in the family dynamics. So, maybe issues that were happening now are resolved then and nobody cares. Maybe our kids are so wealthy, inshallah, all our kids are so wealthy, they don't even care about, what happens with our remaining assets. So it is about preparing for what we really can't predict or know, and minimizing the opportunity for our family members to have these disputes by making our intentions clear. And if we can't do that very well through the legal system, then we have to do it in a creative secondary way, correct?
Yeah, and the living trust really helps minimize these issues. You can actually place the Islamic distributions and have conditions for how they're distributed a lot easier than in a will. But the important consideration is, imagine the scenario where you have, husband passes away, and now all these heirs are receiving their share of a house. So you have like 3 children, a spouse, and 2 parents. Now there's 6 people in the title of a house. One person decides they want to move out and they want to cash out their share. Now everyone is rendered homeless because they're forcing a sale of the home, and the others do not have the means to be able to keep up the home, for example. Now, if you use a trust and you have certain conditions that, for example, the house cannot be sold unless all the beneficiaries agree to it, these are ways of mitigating it without harming the Islamic distribution. So I did say you can give everything legally to one person. There is a way of creating like a hybrid model here, where you can have conditions for, instead of having the 3 children own the house, a trust would own the house, and only with, let's say, the consent of all 3 beneficiaries can the house be sold, for example. And there are a lot of creative ways of protecting yourself from the harms.
Okay.
I think even from the Shari'i point of view, the same scenario, let's say we're talking about, from the Sharia point of view, the house is in the name of both spouse there, and let's say the husband passes away. So 50% is the property of the surviving wife. The other half is part of the estate, technically, where she also has her share, and then the children have their own share. in order to, if you are not making that agreement of, conditional gift, hiba mashruta, then another way would be to write in the will that my portion of the house, I'm giving the haqqus sukna, the right of utilization, to my wife as long as she's alive. This will be her right to use, so 50% is hers, and now my portion also will be used by her as long as she is alive. And you have a concept in fiqh where we talk about habs. You confine it for usage by this wife. It's only when she agrees or she passes away that's where the property will then be distributed among the children. So
So
they
we
are,
have,
even in the Sharia, there's some mechanism where you can maintain at least the residential home intact, at least for the surviving spouse, and divided either according to the mutual understanding or after the second member of this the spouse, surviving spouse, also passes away.
and what I want to do now is discuss the very first steps that we should be doing after this webinar.
Yeah, so as much as this is informational, there's homework. And the homework, and I'm not considering this legal advice, this is just information. It is important, objectively, to have a beneficiary for all assets so that it doesn't get locked up in your names in case you pass away. So bank accounts, potentially the house, 401ks, cars. You can choose primary beneficiaries. You can also choose contingent beneficiaries, which are backup beneficiaries, sometimes called secondary beneficiaries. That's something that every one of us can do right now. And not just can do right now, please kind of do right now. And so these are the 3 steps or 3 takeaways that everyone should be taking from this webinar. Number 1, immediately designate beneficiaries for your accounts, for all your assets that you can. Number 2, consult with an attorney. Now, the type of attorney that you're looking for is an estate planning attorney. Okay, not real estate attorney, not family law attorney, an estate planning attorney, those that work with wills or trusts. And just a general advice, consult with 2 or 3, do not just suffice with 1. And it's important to work with an Islamic scholar as well. Even if for those who are not looking for Islamic estate plans, the general rule is you want to talk to an estate planning attorney plus a financial advisor and an accountant. So just throw an Islamic scholar in the mix, and now you're going to have the best plan for your family and your akhirah. Now, finally, it's always important to have an action plan. Sometimes having something is better than having nothing. And so I have downloaded or prepared will templates for people who like to use them, for those of us who don't have a will or anything in place right now, to potentially nominate 1 person or 2 people as the beneficiaries or choosing the executors. And if you go to this link, bit.ly/willyoutrust, you will access a folder, and this folder will be active for 2 days. So this is not going to be available forever. And you should be able to find your state. Now, some states have given statutory forms, meaning it's sanctioned by the state. Some no, these are these online templates out there. And if your form is not out there, no worries. Contact information is around. You can also reach out and I'll potentially share some of those.
Yeah, a couple of people have asked, how do they find the right attorney and what your contact information is. So over here we have Sayyid Ali Tawfiq's information available. If anybody wants to reach out to him for a consultation or to retain him, or if you have questions about some, getting referral for somebody in your jurisdiction, in your state. But you said something important, which is also consult the Islamic scholar. do you do the will first and then take your whole estate plan and show it to an Islamic scholar? Do you start with an Islamic scholar? What do you think?
Because of the urgency of this matter, I say whoever answers first. Try to get them both at the same time, ideally, but seek them both out. Do not wait for one before reaching out to the other.
Okay. And I think when we discussed in the past, you said ideally they would work together in some way.
Yes. And so it's not difficult to kind of get an Islamic scholar on the same call with you and the attorney to make sure that everything is being fulfilled in that manner. Or your Islamic scholar will give you kind of like a prescription for how they think that you should manage the estates plan, or your attorney will provide different methods. So definitely they should be working together.
And so on Sayyid Rizvi, somebody did mention that the book was out of stock. Will it be available anytime soon? Or are you informed that it is out of stock?
I don't think it's out of stock, no.
Okay. So
everyone on this webinar purchased the book, so if they went out of stock real quick.
So if anybody's having a hard time,
the tool that we have mentioned on the website, that will be even good. For example, even if you're having a difficulty finding an Islamic scholar, you want to talk with your attorney. At least if you go through that tool, it will at the end generate a template with the shares, potential shares, the way you want to use, especially the 1/3 option also. So you will have your numbers there, and then you can take it to the attorney and say, this is what I want to do.
And the tool is available on the Imam website?
No, this is on Al-Ma'arif.
This one.
This one. al-m.ca.
/will. Okay. So we do have some questions, and we have about 10 minutes. If anybody else has questions that hasn't answered, you can type them into the chat, inshallah, and we will address a couple of them as we can. Sayyid Rizvi, how is khums handled when assets are placed in a trust?
How?
What is the implications of khums?
Well, one of the important things that we have to keep in mind that before even distribution of the assets among the heirs, all the dues have to be paid, whether it's legal or shari'i. And in that, one of the issues would be that the khums, if the deceased was a regular khums payer, then you'll calculate from his last khums debt till the time of his death, and that's how you will figure it out, the amount, and that has to be taken out first. And any other debts that he has to be paid off before you even go to the heirs and distribute the shares to them.
What happens if the deceased writes a will that does not follow the Islamic inheritance rule, and the executor is Muslim? Does the executor have to carry out the will or the estate as prescribed by the deceased, or do they have a religious obligation?
Well, I don't think anybody can put somebody as an executor without asking their permission. So before even the person agrees to that, you should have to look at this issue. Are you putting me in a position of following the faith laws or not? And then make the decision.
Well, I can certainly see that, you're young, husband and wife, you make an estate plan. You don't really necessarily at that time in your life think of some of the Islamic considerations or something. And then down the road, you're more religious and you're expecting to, maybe you thought that the person would have changed it. I can see circumstances where somebody could be in the position as the executor, but the will they have in front of them is not Sharia compliant. What's the obligation there for the executor?
I don't think it's going to be that easy. This is the first time you're asking this question. I haven't heard this before, so I don't want to give a
So
judgment in that way.
somebody asked it, so
Oh,
we
okay.
will
Okay.
defer to
No,
it.
it's a very valid question, and I think it's good. At least we perspective. I never thought about it.
Well, so
Um,
for example, my father-in-law is not a religious person. He's going to
yeah,
create a will in
yeah.
the way that he's going to create it, and then to his son, who is religious, might be the executor. So that's
Yeah,
the nuance.
they can be, two different scenarios. One would be that, they, as an executor, you sit down with the heirs and say, this is how the will is, but I would suggest you go this way. This is what the Sharia says. If they agree, then that's the best of situation. If not, then um, I think, before we take on that responsibility, we have to look at it. It would be better to deny, that I wouldn't be able to do it.
Yeah. And so a question that's come up a lot is, what if some of the properties outside of the United States or Canada or the UK, basically, I have some property back in India or Iran or whatnot. Can that be part of the estate plan?
Yeah, so that's where we have a lot of complexity. There are a lot of people who have assets that are not in the United States. Everyone should consult with an attorney for assets that are outside of the United States. So if you have property in, let's say, Canada, in Pakistan, in Tanzania, wherever it is, consult an attorney there. Now, in terms of giving assets to people who are outside of this country, that's also a whole other situation. There are considerations, like sanctions considerations, taxation issues, transfers of property that, may not be as easily transferred. And so there are certain mechanisms that you can use to kind of preserve that person's assets in this country. So you can have, an account open in their name over here, for example. But then you have to, then there are other, again, issues in terms of like Social Security or tax ID numbers and all that. So again, consult with an attorney.
I have seen scenarios where people have actually written two different wills. One is for their assets here in Canada, and the other is, let's say, in East Africa somewhere. So they deal with the areas separately, although they are, following what is the requirement from the Sharia point of view. But just to make it easy, so you deal with the properties over there according to one will, which was for there, and then another one for here. I don't know whether there are some tax implications or not, but yeah, that's I've seen examples like that.
Yeah, I see that all the time. It's very likely that your will over here will not have any sort of effect in a different part of the world, and vice versa.
Yeah.
And so for people who, one question that came up is, if Said Rizvi, you indicated that your perspective is that for life insurance, it's not truly your money when you are alive, and so therefore it becomes created after your death. And if that is the case, can you therefore set up anybody for that beneficiary in full without any consideration? Or is there any considerations we need to think about in terms of naming our beneficiaries for our life insurance?
Well, if somebody has been designated as the beneficiary, then it becomes that person's property. It's not even part of the rules of inheritance there. Unless a person, has a life insurance where he or she designates himself as the beneficiary, then it will become part of the estate. But if somebody else is there, even a family member, and that person has been designated as a beneficiary, then it's their property from the day it was generated. It doesn't become part of this division. And of course, you can designate whomever you want. We, for example, have a system for our charity of the Islamic school that we have. We ask people to take out the life insurance in the name of the school as the beneficiary. We pray for their long life, but that, but and because it's a charity organization, even the premiums that they pay monthly is tax deductible, and so you can designate whomever you want.
So we are at time. We're going to, inshallah, let everybody go. But one question I just want to leave with is, do you have recommendations for a Islamic estate planning attorney? And I wanted to leave with this one because Sayeda, that you had mentioned essentially that there might be just a couple of people out there that have both the Islamic perspective, the Muslim perspective, and the estate planning as a profession. So perhaps people should not be looking for, hey, do you know somebody in Texas that is a Muslim estate planning attorney that and I can trust and I like, those standards aren't where we're never going to get anywhere. You're never going to get anything done. So Sayeda, can you leave off with your final recommendations in terms of how people should just be thinking about this process?
Yeah, absolutely. And if you don't mind going to the last slide. So a lot of this is strategy. Your attorney, you're not going to find, for example, a scholar and attorney in like Idaho or Montana, for example, if that's where you live. The chances are very slim. There's only a handful of attorneys in the country that actually understand Islamic law and how to bring them together. Some have some familiarity, but not too much. Now, the first thing you can do is reach out to those that you do know. So, for example, this is my practice area. I'm more than happy to give you direction if you're not in any of the states that I'm licensed in or my firm's licensed in. If you are interested in me helping you with your estate plan, I'm more than happy to do so, or referring you to someone who I know can. But I can also assist as like an advisor, and you'll find scholars who can assist as an advisor, or other attorneys who can assist as an advisor to some attorney that you already are familiar with and you work with. So don't try to look for that unicorn. You find an estate planning attorney or two, one you're comfortable with, and then bring in help.
And just to clarify, your areas, you said licensed in, can you just identify for everybody what jurisdictions you are licensed in?
Yeah, so I'm licensed in Maryland, DC, California, New Jersey, and Texas. I have a co-counsel, meaning that there are attorneys that I work with in Michigan and Illinois, and there's an attorney I work with Georgia and some other states as well. But that kind of extends who I can help. So if you're not in those states, I can help give direction, how to think about it. But if you're in those states, I can actually help see you to the end.
Okay, inshallah. Any final words, Sayyid Rizvi, before we sign off?
Well, I would just like to emphasize that is an important issue. You have to make sure Allah subhanahu wa ta'ala talks about this issue in the Quran also. We are told a mu'min is somebody who sleeps with his will behind below the pillow, although here not take it literally there. It means somebody who should have the will all the time, and that the emphasis has been there. We only think about this dunya, but we also have to plan for the barzakh and the hereafter. And one of the important issues is to make sure the estate, goes into the distribution in the right way.
Inshallah. All right. I want to thank everybody for their attendance. I'm still getting questions on if people could get your phone number. Say that it's tawfiqlaw.com. I believe anybody could find your availability to book a consultation through the website, inshallah. So, as he said, it is very important that you find somebody and work on this as soon as possible. So for the next 2 days, inshallah, if you look at this URL at the very bottom, I'm putting this up one more time. You will have access to some templates available for 2 days, so that we make sure that everybody actually takes this time while the information is fresh to get some movement and to try to get anything done that you can. But we thank everybody for their time. And I think the panelists again, inshallah, may you all have some clarity and be able to enter this very difficult process gracefully. Assalamu alaikum, everybody.
Alaykum assalam wa
Alaikum
rahmatullah.
assalam wa rahmatullah.
Okay.